Good afternoon, ladies and gentlemen. It's my pleasure to welcome all of you here today and to invite you to join me in welcoming our visitor today, Ms. Shirish Chotalia, who is with the Human Rights Commission of Canada and is here, Tribunal, sorry, and is here as part of our Distinguished Visitors Program. Now, this is a very accomplished individual that we're going to hear from today, who has a whole range of experience in the human rights area that is appealing for us to hear about, and particularly for the students in the audience in terms of thinking about where your careers might take you in the future. So Ms. Chotalia graduated with an LLB and later an LLM from the University of Alberta and launched into an active human rights, immigration and employment litigation practice, which she carried on until 2009, when she was appointed the chair of the Canadian Human Rights Tribunal. She participated during that time as counsel in important cases that made their way to the Supreme Court of Canada, including the landmark case of Vriend, the case where the Supreme Court determined that the omission of sexual orientation from the list of prohibited grounds of discrimination violated Section 15 of the Charter. And so, as a consequence, the court read sexual orientation into the Alberta human rights legislation. And Ms. Chotalia was at the Supreme Court acting on behalf of the Alberta Civil Liberties Association, which was an intervener in that case. She's also acted as on a part-time basis as a commissioner of the Alberta Human Rights Commission and as an adjudicator with the Canadian Human Rights Tribunal. And over the course of her legal career, she's also stood frequently in the podium at the front of a classroom, teaching immigration law, terrorism in the law, and human rights law at U of A's Faculty of Law. She's published two important human rights texts, the Annotated Canadian Human Rights Act and Human Rights Law in Canada, and of course numerous articles in scholarly journals. As chair of the Canadian Human Rights Tribunal, she's bringing about procedural changes that are aimed at enhancing access to justice at the tribunal, and in support of that is traveling across the country consulting with stakeholders. Today, she specifically wants to talk to the students in the audience, but the rest of us, of course, are welcome and probably stand to gain a few insights about the practice of human rights law and how her experience in practice opened her eyes to the challenges of access to justice in human rights adjudication. Please join me in welcoming our distinguished visitor.
I'm delighted to be here. It's a pleasure and a privilege for me at all times to share some of the work I'm doing at the tribunal with Canadians, but in particular, I have two daughters at the Faculty of Law, not the Faculty of Law, at Western in the business faculty, engineering faculty, and so I have to say I'm partial to young people and law students in particular because I'm interested in sharing with you some of the challenges I've had in my personal legal practice and hopefully sharing that with you with a view to opening ideas to you in terms of how you may contribute, what areas of interest might attract you. So I'll begin simply by sharing with you. I love poetry, and so I'd like to begin with with Blake's words: "To see a world in a grain of sand, and a heaven in a wildflower, hold infinity in the palm of your hand, and eternity in an hour." So I feel that, in my practice, I've certainly been privileged to have been able to work with Canadians that have brought various challenges to me. And my view always is, how can I, as a lawyer in a small practice, in a boutique practice, what can I do to make justice happen for these individual Canadians? So I always felt that it didn't matter what area of law each of you chooses. You may choose to go into criminal law, you may choose to go into civil litigation, you may think about labor, various aspects of the Charter, but there's always an intersection, in my view, with human rights. Human rights in the broad sense being fairness, justice, equity. It was always my view, and continues to be my view, that the law is about, comes from equity, and that the law is there to serve Canadians, to help them with those very difficult challenges that they face. And in my own practice, for example, in the civil litigation area, I was involved with a case called Grant. That's the first one there, which is the RCMP turban case, in quotes, where a number of Albertans had brought, or Canadians had brought, a lawsuit against the RCMP commissioner, arguing that it was unconstitutional for the commissioner, the RCMP commissioner, to allow a single RCMP officer who was wearing a turban, a Sikh officer, to wear that turban as part of the uniform. And again, on behalf of the Alberta Civil Liberties Association, I appeared both at the Federal Court Trial Division and the Federal Court of Appeal, and in fact argued that not only was it not unconstitutional, but that in fact Section 15 of the Charter required accommodation and drew from the precepts of human rights jurisprudence as well as, of course, Charter jurisprudence. And so, of course, that position eventually was successful, both at the trial division level and the Federal Court of Appeal. In a very recent case, 2008, just before I was appointed, I was involved with assisting a woman, Miss Walsh, in a case against Mobil Oil. It was a sexual discrimination case and retaliation case of some 16 years at that time, which is still ongoing before the courts. When she went in front of the Alberta Human Rights Panel, she did not have a lawyer, and when I was retained, I had to take it to the Superior Court in Alberta, and it was infinitely more complicated because I had to go through the evidence. Here was an unrepresented person, and essentially she had gotten her BSc in agriculture from the University of Alberta in 1984, or around there, had gone to work sought a job as a landman, which was the title then for a surface rights administrator, and was repeatedly passed over for jobs to men, including younger men, summer students that she trained into the position. So it was a lengthy case, and then we were successful before Mr. Justice McLeod in the Superior Court, the Court of Queen's Bench, it's called in Alberta, in Calgary, and then it went to the Alberta Court of Appeal, and that was sustained, and the retaliation. Now the cases, after I was appointed, of course, we passed the file on to another lawyer who is now dealing with the remedy, and she received a significant remedy in front of the panel, but it's been appealed, so the case is still ongoing. In the area of immigration, again, it was my privilege to have worked with a number of live-in caregivers, domestic workers that came to Canada under initially it was called the Foreign Domestic Worker Program, which is now the Live-In Caregiver Program. And it was, for example, that Turingen case there, she had a particular medical issue with her diet and really needed to leave the employer's residence to just eat her own diet. And that was used as a basis for inadmissibility. The Felipe case, the case underneath it, was a woman who had contracted breast cancer in Canada. She had come here, contracted breast cancer, and was found to be medically inadmissible. And so when she came to me, we took the position that, well, in fact, I brought a constitutional challenge to the regulation of the medical inadmissibility regulation under the Immigration Act. And we were ready to go, and it was settled on the courthouse steps because, of course, the federal Crown said, well, we're going to facilitate her landing. So that was, of course, significant for her, but you can see now there the difference between a case like that and the case that the Dean mentioned, which is under the Labor and Employment, the Vren case, which went to the Supreme Court of Canada. There you got, of course, the Schachter-type remedies. You got the reading in of sexual orientation. You have a decision that you can read and refer as law students, that you can study and talk about. It has precedential value. The Felipe case, nobody's heard of it. I mean, it was just a case where, we were ready to go, but we had to settle it, because if my client sought equity in that case and the Crown was coming forward, then of course our resolution was to make justice happen for that individual. So there's nothing that you could read about in terms of saying, well, how did this, is there a precedential value for that case? Not per se in an academic perspective. But on the other hand, it's my view that I'm hopeful that the case certainly lent itself to consideration at the Department of Justice over the years in terms of those provisions, because obviously it was settled. In the labor and employment field, we've already spoken about the Vren case, and that was a very interesting case on sexual orientation, and I was actually a commissioner with the Alberta Human Rights Commission when the direction was that we are not to, well, we took a decision as a commission at that time based on Hagan Birch of the Ontario Court of Appeal that the sexual orientation, protection of sexual orientation in the Individual Rights Protection Act, which is the Human Rights Act, Provincial Human Rights Act, would be required by law under Section 15. And eventually that was sustained in the Supreme Court of Canada, where the Supreme Court read in the ground. Criminal field, I've done a number of cases. I guess when I started my practice, I started in the area of criminal law. I did an intensive criminal, sort of general practice, but a lot of criminal law. And so when you start your practice, it's a great place to develop trial advocacy, cross-examination, being able to think on your feet, look at the evidence, analyze cases, and it's a tremendous training ground. I would encourage everyone. In fact, I had done a case, and you take on unpopular cases. That is your job. I was only 2 years at the bar, and I was 2 years at the bar, and I brought a constitutional challenge to one of the videotape provisions of the criminal code, which stated that the evidence of an underage complainant in a sexual interference case could be tendered before the court via videotape evidence. My client was charged with this offense, and I moved to have that section struck down, and was successful in that it was held by the Superior Court to be unconstitutional and violating both 11D and 7 of the Charter. Now, one may say, well, that's and that was obviously a very unpopular position, but those were those heady days where we were young and we were excited about the Charter, and we'd graduate and we were testing the Charter. We were testing every article, every aspect. The case law was being developed. So we weren't so, the onus on Section 1 then turns to the Crown, to the government to justify, as you know, under Oakes or Edward Books. But just getting that breach was an exciting and heady time. And in fact, when I spoke at the Canadian Civil Liberties Association National Conference last month, Mr. Justice Ian Binney had just spoken the night before, and it was his last day as the Supreme Court of Canada judge. And he said those were those halcyon days of the Charter, where, so I say yes, those heady halcyon days where, we as lawyers in the legal profession were excited to test this new ground. But having said that, I think today your job may be a lot tougher if you're dealing with some of those aspects, because now often the Section 15 or the Section 11D or the Section 7 breach, it's developed. It's quite developed now. So you have a pretty good idea from a jurisprudential perspective what's entailed. But the tough job today is to engage in that democratic discussion on the balancing of the limits. And that is challenging, and that involves not just the courts, but in my respectful submission, the democratic process as well as the courts, and a commitment from Canadians to explore. Mr. Justice Binney, for example, spoke about the fact that in many countries, police powers, for example, are codified in significant detail, which we don't often see. We don't see in Canada. So it's something for you to think about in the various areas where you feel that there may be a breach of gender equality or the rights to the rights of search and seizure, whatever the area is. If you know that you feel that there's a breach, freedom of association. In fact, I think, where's the case? Right here, Charter, Constitutional, Canadian Civil Liberties. I've done that case for the CCLA, where that was the G8 in June of 2002. And we had moved that the bylaw of the City of Calgary that prevented the gathering or association of persons on the G8 conference violated the freedom of association provisions. And then I moved for an interim injunction because the G8 was coming up. And so I represented CCLA and the Alberta Federation of Labor, and we were in a very, very dynamic negotiating litigation environment. And everything was changing constantly, but we were constantly negotiating with the City of Calgary. And eventually we came to a resolution that the protesters would protest in a certain park that was set aside for the protest, and the result was just at the courthouse again, it was resolved that they would demonstrate in a particular park, and it was a peaceful demonstration. So it was really a satisfactory victory to all sides on that in that case. But again, this is not a case that you can now go and read, but because it was settled. But the pleadings, of course, are there. The affidavits are there. But the interesting thing is, when I happened to speak at CCLA last month, they had an entire panel on it. So it's certainly one of the key areas that often civil liberties organizations are involved in, is freedom of the press, freedom of association. So then I will now take just a few minutes to say, well, when I was appointed as the chair of the Canadian Human Rights Tribunal, how did I, what motivated me to take up the position? And how did my work that I'm doing right now, how is that informed by the work that I did as a private practitioner in a small boutique practice in Edmonton? Well, let's start with the Canadian Human Rights Act. What's the purpose? To extend the laws in Canada within the legislative authority of Parliament, equal opportunity, and have Canadians' needs accommodated, consistent with their duties and obligations, without being hindered by discriminatory practices. Well, it's I would see it as a very broad and moving type of a purpose. I mean, if you you've studied the Business Corporations Act, you've studied the I don't know if you have the Land Titles Act, you have other statutes that I don't think they have the same, they don't speak to the dignity and the emotional realities of the lives of Canadians in the way that this act does. And so, to me, it was, of course it went along with my career, but I'm privileged. It's my privilege to be able to be the chair of a tribunal that has a purpose such as this. Now, one of the limitations, though, remember, is it's an anti-discrimination statute. So when we talk about human rights, we talked a little in the slide before. When I did work, I was doing it in various areas: immigration, civil liberties, all kinds of search and seizure, detention, that kind of thing. Whereas here, the Canadian Human Rights Act is actually a misnomer, and that's really an anti-discrimination statute. So what we do is the tribunal is charged with ensuring that persons in Canada are not discriminated against on these 11 grounds set out right there. And in the areas of employment, housing, services customarily available to the public, hate on the internet, as well as the same pay for work of equal value between men and women in the same establishment. So there's a carve-out. There's a carve-out of what we think of in broad terms as human rights and what the tribunal actually can do. But having said that, it's a very important tribunal. The courts have said that the law that we administer is quasi-constitutional. It's fundamental law. And it goes to the dignity of the individual. And much has been borrowed from the Section 15 jurisprudence, even though that jurisprudence, there are certain very clear differences. Again, one of the challenges that I have in my adjudication, because I'm the adjudicator, sort of like the chief, in quotes, administrative judge of the Canadian Human Rights Tribunal. All the cases that come to us are referred by the Canadian Human Rights Commission. So the difference is that there's a commission that educates, advocates, and investigates complaints. So it wears at least these three hats and refers the cases to the tribunal for a hearing. So then it's even narrower. We're just like an administrative court. Some of the cases that I say, well, why and how does the tribunal help Canadians? I've already told you how narrow our scope is. But you just saw in the news last week the PSAC case of equal wages, gender discrimination. Now, that case, though, took 28 years. And I'm going to come back to that. Hughes. This was a recent decision that we had of one of our tribunal, where we had a person in Ontario who had a disability who could not physically get to the polling station, not once but twice, and was told to literally go down the steps on his, sitting down. And so what happened there is that the member in the remedies that were awarded some very creative remedies in requiring, in consultation with the parties in terms of the hearing evidence, that there should be systemic remedies put into place so that accessibility issues at the various locations were actually made accessible to Canadians. Kamal is a case that, in fact, I was counsel in this Kamal case, and a racial discrimination case, which talked about the type of evidence that may be relevant in a racial discrimination case. One thing I have to say is that this area of law sometimes is a very tough area of law because the proof is often very tough. How do you prove that somebody discriminated because of race or sexual orientation, unless some overt statements are made? And so the jurisprudence is that the tribunal is to look for the subtle scent of discrimination and to look at all the evidence and see if there is that link in making the prima facie case. And then, of course, the onus shifts to the respondent to proffer a bona fide occupational requirement as a defense, for example, in employment, that a policy was rational, proportional, and made in good faith and appropriate in the circumstances, for example. You've probably studied Mayorin and Grismer. Uzoba is an old case, and I put it in here because it was a racially poisoned work environment for a corrections officer, Dr. Uzoba, that went on for years together. And the court, it was certainly held that there was a poisoned racial environment. And so these are just some examples. So when I came to the tribunal, though, I thought, well, I knew that I had a number of challenges. And I apologize for the writing here, but it's so small, but the challenge that I had is access to justice. What does it mean how can I take this opportunity that I have been privileged to accept to actually make a difference for Canadians, starting from day one? Chief Justice McLaughlin of the Supreme Court of Canada said, how can there be public confidence in a system of justice that shuts people out, that does not give them access? That's a very dangerous road to follow. We have a wonderful justice for corporations and for the wealthy, but the middle class and the poor may not be able to access our justice system. So now, of course, Justice McLaughlin is speaking at the level of the Supreme Court of Canada. And I am but a small administrative tribunal. So I'm the one. Along with other administrative tribunals, are trying to put that into place. All of us in this room. We are the ones that have to do this together. So as soon as I started, my vision is and was access to justice for Canadians through expedited complaint resolution, evaluative mediation with a restorative justice component. So why this vision and what is it? That's what I'm going to talk about in a minute. One of the drivers for me is when I started was this case called Mowat. Miss Mowat brought a sexual harassment complaint against the RCMP. She was before the Canadian Human Rights Tribunal. As you can see from the slide, there were about 4,000 pages of transcript evidence, 200 exhibits. Her legal costs were $196,313 before the Canadian Human Rights Tribunal. She ultimately received $47,000 for the legal costs, and up above $4,000, only partially her complaint was substantiated, $4,000 for discrimination. Now, is that justice? How much is she out after having partially succeeded? More like, about $150,000 at the tribunal level. This Mowat decision, the Federal Court of Appeal, look at the date kindly. September 2009, the Federal Court of Appeal, it went on appeal, so obviously more legal expenses. So the Federal Court of Appeal said, you know what? The tribunal does not have the statutory jurisdiction to award successful complainants legal costs. So when I started in September of 2009, I started in November of 2009, 2 months after this decision. I had done a case called Gilmar. At the same time, in September of 2009, I was counsel for Miss Gilmar against the Sioux Nation. She received lost wages of $15,000, loss of pay of $2,200, general damages for discrimination of $14,000, special compensation for willful and reckless conduct of $10,000, and she received her full solicitor client fees, that is my bill, of $25,982. So she received all of that. And that decision came out concurrently with Mowat. It was just maybe just a day or so difference in the release. The counsel for Alexis did not judicially review the Gilmar decision. But you can appreciate that when clients used to come to me in private practice, I would immediately, in 1 hour consultations, I would do an analysis. In 1 hour, you sit down with your client and you say, okay, well, this is your case. This is what I think from a legal perspective, your case, where what we could do, how we could run the case, what the strengths and weaknesses of the case are, what the remedy might be. Very often lawyers don't talk a lot about remedies because they're so excited about liability. But you've got to think about the client in terms of is the client ultimately going to get? And then I would say to the client, okay, now what are your costs? How much are you going to have to pay me? So in this case, I didn't know. I could only guesstimate, right? Say $25,000. Because even here, if you take off the legal fees, what does she end up getting? Say about $16,000 if you take off the legal fees? So if for $16,000 she's taking a substantial risk, because you never know in a hearing how that evidence is going to turn. You don't know what the witnesses could say. It's always I say it's always a, you have four possible outcomes in any hearing, in any sort of trial, hearing, litigation. You're either going to win for the right reasons or you're going to win for the wrong ones. You're going to lose for the right ones, you're going to lose for the wrong ones. So take your pick. It's not a science. The hearing process is not a science, or we'd have a computer. So when I started at the tribunal, I was very concerned. Very concerned about the Mowat case, and I thought, well, what do I do? I need to figure out how I can help Canadians. From my experience, I knew that the access points at the tribunal were legal costs and the need to be heard. These complaints go to the very dignity of individuals. It's very hard to move forward when you feel that your race or your gender are dispositive of those issues in your life where you wish to contribute or you wish to simply live as all others do. So what I decided to do is to say, well, let's look at the tools that I have. These issues, by the way, of costs are not. I was a bencher, an elected bencher of the Law Society of Alberta, and I speak very highly of the legal profession because we are bound by the code, the ethical codes of conduct of the law societies. And if something went wrong in this Mowat case in terms of the legal costs, then it is as much a problem with the system. Where was the tribunal in active case management? Why was this allowed to go for so long? And why was the Peace Act case that came out of the Supreme Court of Canada, why did it take 28 years? Why did the case that I was involved with, even Miss Walsh, why was she, when she came to me, it was 16 years? So what I thought is that was one of my drivers. A big driver was that I've got this, I've got to do something about the Mowat case. Another driver was I have a whole new group of cases involving Aboriginal First Nations claims, because the government amended the Act. They repealed Section 67 of the Canadian Human Rights Act, which now allows First Nations, or requires First Nations to also comply with the Canadian Human Rights Act. Now, the challenge there is you've got individuals. Think about it. When you've got a person who's getting a service at a restaurant or at a bar. In Calgary, there were, for example, complaints that certain black men were being turned away from bars routinely because of the color of their skin. Okay, well, it's not happy, but on a scale of, you could always change and go to a different bar or a different nightclub. But if you're talking about a job and you've been a 25 or 30-year employee, then your vested interest with the respondent company, your employer, is higher. If you're a First Nation member, now you've brought a discrimination complaint against your First Nation. That's your identity. That's where you live. That's where your community is, and that's where your family is. So I've got to find a way. That's where my restorative justice thoughts came in, is I've got to find a way to build those relationships through this process to help the parties to understand the strengths and weaknesses of their case in a mediation where I can offer some evaluation, but the focus is on restorative justice, where we work with the So I will do like a mini hearing, and the commission is always there. Remember, we're not the commission. So I will have the complainant and the complainant's counsel, the respondent and the respondent's counsel, and, say, the commission in the middle. Will always be at every mediation we do. Full disclosure, they've already had the file often for years with the commissioner, maybe a year, whatever it is. So they know what the case is to meet. But before we do it, we ask the parties, would you like to participate in it? It's voluntary. If everybody agrees, then we'll do a sort of mini hearing where I help the parties in session. And I'll actually do it like a hearing so that the person wants to be heard. You can appreciate that these issues that go to one's dignity, people just want to be heard. And Canadians expect to be heard, and Canadians want the justice system to respond to their very real needs. And so that's what I began experimenting with when I started from November forward, is taking the mediation model that we had and adding the evaluative component on a case-by-case basis. No mediation is the same. And focusing it on restorative justice. At the same time, consulting broadly, bringing my Western roots, which is, we have a lot of JDR in Alberta, judicial dispute resolution, so I was used to that. I'm used to the mini-trial model. So borrowing from other court processes, but expanding and enhancing and finding out where those are not working in the court system, how can they work better here? That's the challenge, but that's the excitement for me, is to say what we do here, if we can make this model work, if we can provide a forum where Canadians can be heard about issues that are very close to their heart and go to their dignity, and they can walk out of that room. I'll tell you, when I was a lawyer, a good cross-examination is extremely satisfying. You do that, you do it well. When you gain that skill. Now, with the work I'm doing now, it's extremely satisfying when you find a resolution that works for the parties. Now, of course, the commission is always there, so we have to look at the broader public interest. The commission represents the broad public interest. And we've had a case called Brown, which was in litigation for years together. Have it, but the Brown case is one that went public, in that the parties agreed. This was a case where in Ottawa, the steps between the Byward Market to Parliament Hill were not accessible. And the case was in litigation for years together, and I said, well, this is not justice. Canadian Council of Disabilities was involved. So I had one of my members work with the parties in a mediation context to come to a settlement that involved a significant public interest remedy, in that the complainant, Mr. Brown, was now sitting, part of the settlement was sitting on a committee where he would be involved in giving input into every new project that comes forward in the city of Ottawa. So that type of a remedy and that type of a position allows him not only to have input into the current issue of the steps, but also to move forward and to look at how that remedy can have make a systemic difference for Canadians. In terms of the benefits, then, in general, for the model that I'm implemented here. Obviously, the Mowat case, Supreme Court of Canada last month upheld the Federal Court of Appeal and said that we don't have the statutory jurisdiction to award solicitor-client costs. That's now the definitive law, and I'm as a tribunal, as an adjudicator, I'm bound by that law. Ramifications, obviously it has significant ramifications for Canadians that are disenfranchised, marginalized. And of course, again, we talked about the Section 67, the First Nations types of cases. So I've offered a model where we are also doing, if it doesn't resolve by mediation, intensive pre-hearing case management. So I'm bringing the hearings under control, meaning only call evidence on those issues that are in dispute. It takes a lot of front-end work to do that. It's not easy. And I started as soon as my second day, I was November 2nd I started, and my husband said, oh, well, you're going to go there and read the newspaper. And I said, when is that day coming? Because it hasn't come yet. It's been long hours, but satisfying because we're moving forward. In the first year, I did some 16 mediations, and 14 of them were settled by the parties. We did 30 altogether with my members. Basically, I started and worked on the model in consultation with Canadians and then brought on members one by one by one. So it's not the settlement rate. This can fluctuate. 80% could be one year, 80% another year, it could be 30%. It's not the number that's important for me, but the restorative justice component that they've had disclosure, they've had an opportunity to be heard, they've had an opportunity to access the justice system with their lawyers, if they have, without their lawyers, if they don't have, but have that opportunity to avoid those legal costs if that's attractive to them. And in fact, I won't take, I know you want to ask some questions, so I mean, there's examples of cases where we've brought these hearings down to a week, 2 days. I don't want to get too much into your civil trial advocacy, but we look at really narrowing the expert evidence, doing different things. If you're interested, please have a look at these cases online, Ruth Noreen, and you can see where I've put in. I'm also trying to keep the decisions under 25 pages where possible. No citation of the evidence, make the findings of fact, put them out, put concise legal principles, and then do your analysis. You guys are in law school, and if we're adjudicators, then we need to do it too, right? So lots of, that's what I said, decisions under 25. Again, our standard of review from an administrative perspective is, of course, reasonableness. We have full deference on our findings of fact. So that's where our strength in adjudication is make those findings of fact. And all adjudicators need to have that, have that duty, in my view, is to make those findings of fact clearly. So, in sum, I would say that it's my privilege. I've been consulting extensively with Canadians, and we've already come, in fact, to Winnipeg. I was here, I think, last month. And we've been to Toronto, Ottawa, Vancouver, Calgary, Edmonton, Halifax, Fredericton. I've also engaged in discrete consultations with First Nations communities. So there are 663 First Nations communities, so I can't certainly do all of them, but I've done at least 10 or 12. I've started on the Shubenacadie in the East Coast, Musqueam in the West Coast, Tsutsina in Calgary, Fort McKay, here in Peguis outside of Winnipeg. So a number of them to consult about the process. And in sum, I could say that I am invigorated. And when I see young people like you, law students, I feel that your contribution, either through SLS or any other mode that would be appropriate, both as law students and or in your own practices, to think about how you would like to contribute, if you would like to contribute in this important area. I certainly invite you to do so. And I'll end with one of my father's favorite quotes of Mahatma Gandhi. Emotion and imagination make a poet. Introspection and retrospection make a philosopher. Daring and dash make a hero. Tact and strategy make a warrior. Wisdom and foresight make a statesman. But service and sacrifice make a saint. So I think that all of you have that opportunity. Thank you for sharing your time with me.